Hi, I'm Michael Wald. I'm here to answer your legal questions. Today I'm with Steve Green, one of my colleagues and friends. We're going to tell you a little bit about wills. Steve, why does somebody need a will?
Well, you need a will because without a will, the state decides where your property is going to go when you die.
And if you die without a will, what happens?
Well, the laws of the state of Texas decide under intestacy that your property will be distributed to your heirs, and your heirs are determined based upon the number of marriages you've had, number of children you've had, when those marriages were, when, how many children you had from previous marriages, children you have today, and how the property needs to be divided based upon all of that.
So if I'm married and I have a house and I die without a will, my wife might not be able to sell the house? Is that what you're saying?
That's exactly what I'm saying. Your wife may be able to live in the house for her lifetime, but she won't be able to sell the house. And that creates a whole lot of problems for, first of all, inter-family disputes, lots of issues regarding who's going to maintain the house, pay taxes on the house, and things like that. So when you have a will, it makes things a lot easier because it answers many questions and takes care of a lot of issues that you don't have to deal with without a will.
What are some of the other things you need besides a will?
Well, you need to make sure you have a medical power of attorney, because if you can't make a medical decision for yourself, obviously you've got somebody else who can make the medical decisions that you need made, especially in emergency situations, as well as a durable power of attorney, because you'll need financial decisions made on your behalf when you can't make them. With the medical power of attorney, you need a HIPAA that gives the medical power of attorney the opportunity to look at your medical records and make informed medical decisions. And then there are other documents that are important, things like a declaration of a guardian in case you aren't able to, or you're not mentally able to make decisions for yourself in the future. You've determined who you want to be your guardian. That takes a lot of issues out of play in terms of the requirements of bonds and things like that, and who's going to be the person in charge of you in the future. And upon death, you can also decide who's going to be in charge of your body. And those things, a lot of those questions can be taken out of play.
As you can see, a lot of this is very complicated. You should obviously consult with a competent attorney about this, and our contact information will be posted with the video. Thanks.
Thank you.